Order. Good morning, everybody. Welcome to the Housing, Communities and Local Government Select Committee. I'm Florence Eshalomi. I'm the chair of the Select Committee. Can I ask my committee colleagues to quickly introduce themselves, please?
So I'm Gag Mahindra. I'm Conservative Member of Parliament for South West Hertfordshire.
Lewis Cocking, the Conservative Member of Parliament for Broxbourne, and I am a leaseholder as well.
Morning, Lee Dillon, Member of Parliament for Newbury.
Will Forster, Member of Parliament for Woking.
Sean Woodcock, Member of Parliament for Banbury.
Chris Curtis, Member of Parliament for Milton Keynes North.
Morning, Andrew Lewin, MP for Welwyn Hatfield.
Hi, Sarah Smith, the MP for Hyndburn and also a leaseholder.
Andrew Cooper, Member of Parliament for Mid Cheshire.
Maya Ellis, Member of Parliament for Ribble Valley.
Our session this morning is our second session on looking at the pre-leg scrutiny of Commonhold and Freehold leasehold legislation as laid out by the government. Can I ask our guests to introduce themselves, please?
I'm Philip Rainey, KC. I'm a barrister in private practice at Tanfield Chambers. I've been specialising in property work and leasehold work for more than 30 years. I have previously been a member of the technical support group for Commonhold, and I probably should declare I also do own a leasehold flat with a ground rent.
I'm Mary Knowles. I'm a solicitor in private practice. I should also declare that I work part-time for the department as a lawyer. This was disclosed prior to my invitation. And I basically specialise in landlord tenant and commonhold. Most of my work is on behalf of leaseholders, but also resident management companies and right to manage companies.
And my name's Douglas Maxwell. I'm a barrister in private practice at Henderson Chambers in London, and I have a background in property law and human rights, with a PhD in property law and human rights and a book on the topic.
Thank you for coming before the committee this morning. I think it's fair to say the issue of commonhold has been a long-running theme in the last Parliament and now in this Parliament. Obviously, the Commonhold Act passed in 2002, and unfortunately we've only seen a very small number of commonhold developments established. Just an opening question to the three of you. What do you see to be the key changes in the legal framework in the commonhold and in this draft legislation, and what changes would you want to see in future developments?
Briefly, the most important thing is simply the sunset clause on leasehold, because it's not a criticism of anyone, but the fear of the new, when there's an established system, unless there is a sunset clause, which there wasn't under the old Act, it's unlikely that you'll get a high degree of take-up. And secondly, the ability to convert to commonhold without 100% agreement of all leaseholders, freeholders, mortgagees and so on, which in practice is impossible to achieve. The other change which is important is the ability to have sections in the commonhold and different service charge pots. Because under the old Act you could only have a single service charge with a single percentage, so the commercial units had to pay towards the same things as the residential units, etc. Therefore you couldn't in effect have mixed-use developments or even two towers on the same estate. Those structural changes are in my view the most important things, and should allow the commonhold to be delivered. Very, very briefly, I think there's a danger of overpromise in the sense that you can change the tenure of a building, but at the end of the day it's a building with flats in it, and if the roof leaks it costs exactly the same to fix the roof on a commonhold building as it does on a leasehold building. So I hope that there won't be an overpromise of lower charges for everyone. There may be because of better democratic control, but if something goes wrong with the building, it will cost the same to fix because the contractor won't care what the tenure is. And then I think, because I don't want to take everybody else's time, I think there are a couple of omissions. One thing which doesn't seem to me to have been thought of is that there's another document which is the contract for sale of the commonhold unit off plan. So in a new commonhold, the developer will be selling off plan. So someone needs to think about perhaps whether there should be controls over the contents of that contract. To take one example, it said the developer can't control who the directors are because after 50% of the units are held, the common holders will have control. but could there not be a clause in the contract of sale which requires the unit holder to vote the way the developer tells them? That's one example. And it wouldn't be difficult to do something about that, but you do have to think, when you're thinking about a new commonhold, that there will be a whole raft of contracts in place at the beginning of the development.
Yeah. Okay.
And then the second thing, and I would like to say this, there are a number of statutory time limits in the Act, for instance, for unit holders to challenge non-essential expenditure, for instance. They have a month to do it. I'm not clear that there's a power in the tribunal to relax that 1 month deadline in an appropriate case if it's just and equitable, because that's a statute. If Parliament puts a statutory time limit in, then the courts and tribunals can't simply override it.
Thank you. Mara.
Thank you. Mine is twofold. So I think transparency is absolutely critical to making commonhold work. We are asking commonholders in the building to vote on critical decisions such as on reserve fund, budget setting, and if those commonholders don't understand what it is they're looking at, it's very, very hard to get an accurate vote in favour and in support of those documents. For example, understanding what a reserve fund is. In the bill itself, I think there will be an opportunity for secondary legislation. There's nothing necessarily that needs to go into primary, but it is very critical that there's some kind of detail in respect of better transparency to make sure commonholders have access to all the documents that they need. The second is, following on from Mr. Rainey's comments, is education. One of the fundamental problems with the leasehold system is taking into account my experience speaking to many, many leaseholders, is the lack of education on their side, not because they're not willing to, not because they're not intelligent enough, it's because there is no proper education facility. And a lot of leaseholders come forward, they talk to me and they say, take a breach of lease, for example. I carried out alterations in my flat. I wasn't made aware at the time I bought my flat that I needed the landlord's consent. I'm in breach. Now my landlord is trying to forfeit. If leaseholders understood their lease to begin with, a lot of the problems that we see in the current system would not exist. And commonhold, I think, will only really be successful if it's implemented properly. It's not a legislative problem, it's an implementation problem.
On commonhold itself, I'm going to limit myself to the expertise of those sitting to my right.
Just one final question. Obviously, I think this draft bill aims to address and fix some of the issues. Would you say there are any key elements that are a glaring omission and not contained? And you know, sort of very quickly, what improvements would you suggest if you had the opportunity?
I don't think there's anything which I would identify as a glaring omission. There are some things that we don't know, in the sense that there are regulations which will fill in a lot of detail. I mean, one classic example of that is the section provision. So at the moment, sections are clearly a good idea, and they are an answer to the problems of the current bill in terms of phased development.
So do you think that will help in terms of the interests of the commercial and residential units?
Yes.
If you have that in okay.
Well, both, and the developers, because you will be able to set. At the moment, what would happen is the developer would plan it out, and you'd plan different service charge pools, and you'd work out which leaseholders are going to pay towards what. And you simply can't do that with commonhold. Under the new regime, it's not a lease which provides it, but the sections will provide it. So it will allow developers, at least in principle, to plan their developments in the way they do at the moment. And it will also mean that unit holders only have to pay towards the facilities that they're entitled to use. That's all good. But there are regulations which are going to govern when you can create a section. And so a potential problem would be if someone created regulations which were too restrictive, because then you effectively build in the problems of the old bill.
Okay. Just mindful of time, I'm going to move on. Mayor, please.
Got a few questions about commonhold associations, and I was really interested in what you said, Mary, about education and kind of so just kind of looking at how we move people into this sort of new way of working. Do you feel that the draft bill sets out fair systems for those decision makings in commonhold associations, and do you think that they will work as the government intends in most cases?
The bill itself, yes, absolutely. I think the foundations are there, but any good legislation is also dependent on successful implementation. And my serious concern right now is the lack of support for commonholders to understand what it is they're voting on. So I think that's my concern. It's not something that could be legislated on. but it really does need robust enforcement.
Yeah. So in terms of this committee in our report, are there things that you feel that at a national level that government could do or could be doing to sort of help create a framework or something to make sure that does happen?
I think there might be potential in secondary legislation in certain parts of the Act itself which could be used as an opportunity. So, for example, there's a provision in the draft bill in relating to voting systems. We could put something in there that clearly says, statutory instrument, these are the documents that must be provided before a vote is taken to make sure that everybody understands what it is they're voting on. But in terms of a national level, I mean, the Leasehold Advisory Service has greatly improved over the last couple of months, and I know that leaseholders are now getting a lot of support. Even 2 or 3 years ago, there was very, very little resource for leaseholders, but now on the Leasehold Advisory Service, they've got webinars for leaseholders. The building safety team has really good videos and explanatory guidance for resident management companies in particular. So it is improving, but this has to be robustly implemented for Commonhold. You do not want someone buying a flat or a unit who doesn't understand what it is they're buying, because if they get invited to a vote and they don't understand what a reserve fund is and the benefit of a reserve fund, it's going to be extremely difficult to get these votes passed. And I know that managing agents in particular are very concerned about the stalemate situation where they can't get budgets signed off, they can't get the reserve fund signed off. It's the practicalities of that. And I think educating common holders to understand what they're voting on will go a long way to easing a lot of the concerns that I know managing agents have in particular.
Thank you. And just anyone else that's come in on...
Yes, I mean, I think that one of the things, when you're looking at, as a committee, at the votes, you've got to remember that unless it says it's percentage of members, it's a percentage of those who vote. So the key then is the quorum. Now, under the current regulations, the quorum for a Commonhold Association meeting is 20%. So if the bill says 75% of those who vote, in theory, that could be 75% of 20%. So certain things can pass at 15%. If it's an ordinary resolution, it is 50% of 20%, i.e. 10% of the members. So certain things are actually easier to do than you might think. Two points which I think are quite important. The first is the Commonhold Association is a company, and therefore the commonholders will have to learn to comply with company law unless the Act says otherwise. So there's an education piece there, but there are also a lot of traps in the technicalities of the Companies Act. And I would suggest that the tribunal should be given the power to waive minor defects in procedures which don't affect the result. In fact, I would suggest that the committee might consider recommending that there are wider powers to relax requirements of the Companies Act for Commonhold associations, because it's not a big PLC. There are certain things that really should ordinary people in voting, perhaps in somebody's kitchen, really have to comply with. And so I would suggest that you could usefully put in a provision that those are relaxed. You might even put in a provision which says that the current precedent of case law for ordinary Companies Act matters doesn't have to be applied rigorously to Commonhold associations.
And just finally, can I just ask, sort of 5-10 years long term, what you've touched on it a bit more, but what are the risks, I guess, if we don't get that education right? You've highlighted some of the challenges, but what's the impact of that in 5 or 10 years once this all comes into play, if people are really struggling to understand and make use of that Commonhold?
I think it will directly impact the quality of the building is the primary concern. I'm sure lenders may be speaking to you later on in the evidence. They will no doubt have views on the condition of the building. I see quite regularly, I've got a couple of right to manage companies who traditionally haven't paid into the reserve fund. They've all contributed the absolute bare minimum into the reserve fund, the reserve fund, the service charge, and they carry out the absolute bare minimum works, and now it's severely dilapidated and they're all looking at 5-6 figure bills. We want to prevent that. Prevention is cure.
Nothing really to add to that, apart from inevitably, if Mari is right, and I think she is right, lots and lots of ordinary blocks run with insufficient reserves. The positive is no unwelcome bills in 10 years' time. The negative is that the yearly bill will be higher than some people are used to, because they're used to running on a shoestring.
And then finally, just on tribunals, do you think the sort of recommendations around tribunals are sufficient, or is there anything else you'd like to see changed? You touched on it before.
As much jurisdiction as possible for the tribunal, having to take Companies Act proceedings in the Companies Court is potentially a disaster. As I've said, I think that I'm not sure that Section 97 gives the tribunal a power to waive either minor defects in procedure necessarily, but certainly to vary statutory time limits in the Act. I have to say, Section 97 is quite short. The regulations are going to have to do a lot of heavy lifting in dispute resolution.
Thank you. Do you want to come in, Andrew?
No, but it's really interesting.
Well,
thank you, Chairman. Douglas, what do you think the likelihood is that freeholders will seek a judicial review of the proposed legislation if it's passed in its current form? And then if you think they are going to do it, what do you think the likelihood is that legal challenge will be successful?
Dealing with the first question, I can't speak on behalf of freeholders of what they are and are not going to do, but say taking one of the proposals, which is probably the most significant interference, which is the capping of ground rent at £250 with it going to peppercorn after 40 years, it seems almost inevitable that there will be a challenge brought under human rights legislation. That reform, the economic impact, will be far more draconian than the current LAFRA that's being challenged in the courts at the moment. So based on that, it seems almost inevitable in the current form that it will be challenged on human rights grounds. In terms of whether that will be successful, again, that's not really something I can comment on, and there's not probably enough information at the moment in the public domain to determine that. It would be helpful, and I appreciate you all are asking for this as well, to have the consultation response to the 2003.
We have requested that.
And it would also be helpful to have an impact assessment of this reform. I know there was an impact assessment with the original consultation 2023. I know there were problems, issues with that, and some figures are quoted in the policy documents for this as well, but it's really for this committee to scrutinise that consultation, the response, the impact assessment, and it all comes down to this question of fair balance. And while it may be unpopular to many, Lord Hope in the Supreme Court case of Salvesen Riddle said, landlords, however unpopular, are entitled to human rights like everyone else. I appreciate that human rights property may sit in a somewhat odd space within what we'd normally consider to be human rights, but they are entitled, and ultimately Parliament has determined that through the Human Rights Act, through ratifying the European Convention of Human Rights. Whether that will be successful really depends on a myriad of factors, and thankfully I'm not the judge who'll have to determine it.
What would you advise the government to consider in terms of action or amendments to reduce what you say is sort of inevitable legal action?
I think in short, there's probably very little if there's going to be some form of cap or reduction in ground rent that's not going to result in a challenge. But what the government can do is reduce the risk of a successful challenge. Again, the consultation response on ground rent would be helpful to see how that pans out, but there are options. So, for example, the policy goal here is reducing in the manifestos to tackle unregulated and unaffordable ground rents. The question is whether that in and of itself justifies the £250 cap, and also where the 40 years has come from. I assume it's come through legal advice as that will reduce the possibility of a successful challenge, but it's not entirely clear from this side where that 40 years has come from. Now, for example, this is a point that Philip noted, so I'm not claiming any knowledge of this. The Rent Charges Act in 1977 abolished ground rents for freehold properties, and that gave a 60-year sunset clause. So there are certain examples of ground rents for freeholds that are not going to end until 2037. So there are different ways of doing it, but the real question, and I appreciate people have very passionate views on ground rent and what it is and how it's paid, but the real question is whether £250 a year is really an onerous ground rent, and also whether that actually tackles the bigger issues, which have really been the real issues with leasehold, which have been the issues of doubling ground rents. Yeah. Because that's very much, and I accept there's only so far a government can go to actually tailoring legislation to the facts. But if you think about the fair balance, so is it in the fair balance for government to legislate to take ground rent away from a charitable trust who uses that money for its charitable purpose, to give that effectively a windfall to an offshore private landlord based overseas? Now, I appreciate that's an extreme example, but that's really the issues for this committee to consider. And I appreciate that there is a spectrum of ground rents and there is a spectrum of people who effectively benefit from it. But it's important to look at the full spectrum, and going back to what Lord Hope said in Salverson, however unpopular landlords are, they're still entitled to the protection of the European Convention on Human Rights.
That's helpful. At last week's Select Committee, we had the two former Secretary of States appear. They said ground rent is money for nothing. I've had this said by leaseholders in my constituency of Woking. They are paying ground rent for effectively nothing. We've had examples where, oh no, it's the service we provide for the building. Well, that's the service charge. If a lot of opinion ground rent is money for nothing, why would a legal challenge on human rights grounds be successful? Do you think the government's got the balance right on that sunset clause and change to peppercorn? And then finally, you've mentioned the 1970 Act. Most changes in legislation don't get a 40-year transition period. This is an extremely sort of government has been extremely nice to plan that far ahead, whether it's WASPy women or student loans or other things. It's almost instantaneous changes. Why are freeholders getting such a good deal?
I can't answer on behalf of freeholders. In relation to your first question, so the way A1P1 works is it relates to possessions, so that's something with an economic value. So the lease, the contract, is what gives it that value. It doesn't look at the subjective question of what ground rent is for, whether it's, in your words, money for nothing. It's an economic asset that exists. There isn't really any way of getting around that. There are many assets that we may say, or many streams of income that we may have questions about the morality of it, but ultimately if they exist in the lease and the contract, they're possessions under A1P1. In relation to, your second question beyond that was about...
So it's such a long transition period, 40 years. It's almost unprecedented. Surely that reduces the legal risk. Surely that is the government being very fair to freeholders.
It's part of the balance that the court may have to make about that sunset clause, but ultimately it's still quite a significant interference in a large number of assets. The economic impact is significant, even though we have limited figures from the government so far. We know the impact is significant. It's also quite an unusually large retrospective interference in property rights, rewriting contracts. But again, ultimately it may be for the court, and the court, when considering the fair balance, takes a kind of myriad of factors, and the points you put forward will undoubtedly be put forward on one side and considered by the court. But I think there does need to be some proper consideration of where that 40 years has come from. I assume it's based on advice that's been received about limiting the possibility of a successful challenge.
Trying to get to the bottom of that, don't worry. Andrew C.
Thank you. If Parliament, this is a question for you, Douglas, if Parliament legislates to ban ground rent, which is what it will effectively be doing if this draft bill becomes a bill and is passed, then Parliament is expressing the view that ground rent ought not to happen. Regardless of what we may think about that, Parliament is saying ground rent shouldn't happen. And what we're arguing over here is the length of the sunset clause, which could be between 0 and apparently 60 if we were to take the example of the Act from the 1970s. So if you were offering advice, Douglas, to us, to MHCLG, what factors would you say should be considered about where to draw that line? The government has said 40 years, but what advice would you give on where it should be drawn?
It's exceedingly difficult in the confines of a minute and a half to give an answer to that. It's also exceedingly difficult for the points I raised earlier, that we don't have the consultation response, we don't have the impact assessment. And while Parliament is sovereign, has its own will, Parliament's sovereignty is also expressed through the fact that Britain is party to the European Convention of Human Rights, and also that Parliament in the late 1990s legislated through the Human Rights Act, which mirrored the majority of the Convention rights in Schedule 1. And in doing so, Parliament effectively accepted that there was a certain limit on what can be done. And unfortunately, if human rights are working, they tend to be quite unpopular with Parliament because it places a limit on
Parliament's powers.
And that is, in my opinion, I'd say a good thing that we have human rights legislation that place those limits. I'd hope that members of the committee would agree with that.
Yes, some of my colleagues may want us to leave, but that's for another day.
But ultimately, the human rights property is not an absolute right, it's a qualified right. And it will be for a court to determine where that, it's primary for Parliament to determine, and then it may be for a court to assess whether that complies with the case law of the European Court of Human Rights, which Parliament has said should be taken into account.
Okay. Thank you. Lewis, and then Andrew is to finish this section.
Douglas,
please.
based on what you know now and all of the evidence and your experience and what have you, where would you draw the figure? How long would you give?
That's why I'm glad I'm not sitting on this side and I'm not Office for Parliamentary Counsel.
Obviously, I've got a lot of experience, you know a lot of the detail behind all of this. If you were advising government, would you say 5, 10, 20, 60?
I'm not sure if simply looking at the sunset clause is enough. I think there may be an issue that whether simply a straightforward cap of £250 really does meet that manifesto commitment to tackle unregulated unfair ground rents, because there's a full spectrum where ground rents can be significantly higher than that and wouldn't be considered unfair, when the real issue of ground rents more recently has been with new build houses and doubling ground rent clauses. There's some really interesting work by a professor at Oxford called Susan Bright who looks at the consumer rights impact of this, which, if you're interested in that, is something the committee should look at as well.
Thank you. Andrea.
Thank you, Chair. Shared ownership is a growing tenure, and committee colleagues are bored of me saying that that's how I got on the housing ladder before I had grey hair. But I think it's a really important part of the conversation for Commonhold. And I wanted to ask you today about practically how might this work, particularly if we take an example where someone owns 25% as a shared owner and the registered provider owns 75%, which is not uncommon at all when people first come into shared ownership. How could that practically work in a Commonhold system where people are exercising votes, and how would you see that practically playing out? And does the bill at the moment provide enough specificity in that situation?
So Section 18 of the draft bill does indeed provide for shared ownership. The bill is divided into two sections, so existing shared ownership leaseholders, and there's a definition of what a pre-registration shared ownership leaseholder is, and there's one set of rules for existing shareholders who end up converting into a Commonhold from existing leasehold. There is a second set of rules that relates to new shared ownership leaseholders who come into the market in new Commonholds. Section 18 does go into it. We are, however, waiting for secondary legislation, which may take time to come before we actually see the detail of that, how that will work. In particular, for example, Section 18, subsection 1 sets out provision for statutory legislation that sets out how all of that will work. In terms of the protections for shared ownership leaseholders, I think they will have a stronger position than what they do under the leasehold system. They will be able to participate more. There is a concern over that initial 10-year period, which I do have concerns about, but that isn't a problem with this draft bill, it's a problem with the shared ownership model. In case of interest, I would recommend reviewing the Levelling Up Committee report on the 28th of March 2024, where this committee looked at shared ownership model and all of those abuses and problems that we do see in private practice in respect to shared ownership. The government did respond to that, I believe, in July 2024, 2024, and one of the first items in the recommendations was that there does need to be change within the shared ownership model, especially around who pays for service charges, for example, because they recognise that there is an imbalance, there is an injustice that really does prejudice shared ownership leaseholders. But this Commonhold bill, Section 18 in particular, improves the position as against the leasehold system, but the shared ownership problems really need to be addressed at source, not through this bill.
One follow-up if I can. You said the problem was with the model and not the bill, but if I can, and I appreciate that this requires secondary legislation, but if I can press an example, I'm just interested in your thoughts. Let's say you're 7 years into your 10-year qualifying period. There's quite an urgent need for major works. You have a 25% share. The registered provider has a 75% share. How do you think we can grasp that nettle in terms of where the voting powers ought to be? Because the registered provider might have a legitimate claim, so, well, we own 75% and we think we should do X, and the owner might think, the shared owner might think we should do Y. At the moment, I don't think we have an answer to that.
I don't, at the moment, the registered provider wins out.
Yeah.
And that's, I mean, I think that there must be some nuance which is capable of being built into the legislation, because at the moment, the way it works is that during the 10-year qualifying period, it's the registered provider which is the member of the Commonhold Association and not the shared ownership leaseholder. So logically, the shared ownership leaseholder has no vote on, as I understand it, anything subject to anything which regulations might say. And I mean, even if they had the right to attend Commonhold Association meetings as a non-voting member or a right to speak, because of course, I mean, it might be that they have views which they want to impress on their neighbours as much as their own landlord, but at the moment there isn't anything which, for instance, requires the chair of a Commonhold Association meeting to let a non-member shared ownership leaseholder attend and say anything. So I mean, I mean that's a very small point, but I mean you could do something like that. A better point would be to have some kind of mechanism for resolving a dispute between the provider and the shared ownership leaseholder about a vote during the qualifying period.
Just one final question to Mari. Obviously, in terms of the conversion process, you've got non-participating leaseholders. In a sense, they could get out of paying some of the enfranchisement costs. Is this something that you think that we should be pressing ministers on?
I think with the conversion process, what's fundamentally different is that when you've got a new block and 100% are common holders, those common holders voluntarily accept its common hold because they've bought into it, they know what they're getting, their conveyancers are properly advising them on it. With conversions, where you have non-participants who are joining that process, I think it's really important to think that not all residents in a building share the same views. And I think this is a concern. So there will be existing landlords who may, under the Leasehold Reform Act 2024, they will still have retained interests. You will also have non-participants, and some of those non-participants may not just be reluctant to the process, they might be proactively obstructive. And indeed, we do a lot of collective enfranchisement claims, right to manage claims, and there's usually one or two in a building who are absolutely against it. You know, they've got their different motivations. And I think this comes back to the voting problem, is in that scenario where you have got people who are perhaps reluctant to convert and they don't want to be there, but they've got voting rights. That may create a little bit of a problem for managing agents in particular, who may struggle to get those votes that they need.
I think we're going to comment to that on our second panel.
Yes.
But just to thank you all for coming before the committee this morning. We'll continue this engagement and discussions. Order. Welcome to the second panel on our Commonhold and Leasehold pre-leg scrutiny. Can I ask our guests to introduce themselves, please? Vanessa.
Thank you. Good morning. My name is Vanessa Griffiths. I'm a chartered surveyor and a partner in the leasehold reform and litigation team at Knight Frank. I act for both leaseholders and freeholders and have over 15 years' experience in that sector. And I sit on the RICS Residential Professional Group panel. Thank you.
I'm Mark Chick, a Director of ALEP, the Association of Leasehold Enfranchisement Practitioners. That's a not-for-profit body that acts for solicitors and surveyors working in the field of enfranchisement. I'm also a solicitor in private practice. I'm senior partner at a firm in central London called Bishop & Sewell. I've spent the last 15 to 20 years working in this sector.
I'm Emily D'Albuquerque. I'm a Director and the Senior Lawyer at HM Land Registry.
And I'm Philip Freedman. I'm a solicitor in private practice, a consultant at Mishcon de Rea Solicitors, who I must disclose are involved in some of the litigation matters that you've mentioned earlier, although I'm not handling them directly myself. I'm a member of the Law Society's Conveyancing and Land Law Committee. I'm on the working groups that prepare the standard conditions of sale and the Law Society's transaction forms, which would be relevant for use with Commonhold. I was a member of the Ministry of Justice's working group about 15 or 18 years ago, looking into why Commonhold wasn't widely accepted. So I've actually been involved in Commonhold matters for quite a long time. I am here today to represent the Law Society. The Law Society wants to assist in making Commonhold successful, and we do have some suggestions to make.
Thank you very much. Thank you all for appearing before the committee. Obviously, there's current provisions in the current law in terms of converting a block from leasehold to commonhold, but equally there are some challenges in terms of making sure everyone signed up, unanimous consent of all the leaseholders, and the consent of the freeholder. If we put an example of a leaseholder in a block with a third-party freeholder, what would be the main advantages of those leaseholders converting to commonhold?
I think that's a tricky question to answer, especially if they've already done the enfranchisement process, because they've already essentially got control of that building, and the conversion to commonhold doesn't necessarily benefit them any further than that. In one sense, the enfranchisement process is better because it removes that existing freeholder completely. Whereas, of course, then if they're still going to convert to commonhold, the existing freeholder is still present if they're obligated to take ownership of the commonhold units of those non-participating units. So I don't think it necessarily addresses that issue. In comparison to enfranchisement.
I think centrally, if a block enfranchises, obviously if they take away the third-party freeholder, then put in control of their own destiny. And so we've got to really look at the difference between commonhold and leasehold in terms of how that budget is set. We've heard from the previous panel about how the ability to set what will be the commonhold community assessment will be key to this, and understanding the nature of the costs and charges. And as Philip Rainey said a moment ago, it's not necessarily going to be the case that things will be cheaper in that environment. So the difference is probably one of what might be called the democratic deficit, really. So there is now a structure in which people are in control of their own destiny, in the same way they are in a post-enfranchisement scenario. How good are they going to be at taking control of that? That's the challenge, and I think education and training are key. One thing that we, as ALEPs, would certainly support is the provision of Section 101 of the bill, which says that the government will put aside resource for training and education in relation to this. Because
do you think the cost of collective enfranchisement could be a barrier for some?
Well, I think that's an important point to come on to, and I'm glad you mentioned that, because I think when we talk about what will happen and what will incentivise people to do this, commonhold will need to be better than leasehold. If that's to be the case, we've got to look at how this is going to be rolled out. And I think I and a number of other people on this panel here today share the view that actually a phased implementation would be good. And I think whilst we're here to talk about conversion, and I've got lots to say to you about that, it would be really key if we could think about the rollout of this. And I suspect it would be far better if commonhold were rolled out for new build developments where there is 100% participation on day one because of the very nature of the system, before we start getting into the mechanics of how we might take an existing structure and then convert that into commonhold. And I think if Commonhold is to have the acceptance and people are to understand what it involves, then it's far better that those that have the resource, the developers and the industry, put themselves behind that with appropriate backing on day one. And I think that's key.
I think there's two things that you outlined there, because a challenge back to you would be our inboxes from collective residents and constituents who are leaseholders. They are seeing their cost increase on an almost monthly basis. A number of them have highlighted the fact that that they are facing almost financial ruin because of the cost. And you're saying you're suggesting maybe in terms of the government enact this on new flats. Whilst we tackle that, get everyone on board, and then deal with existing leaseholders.
The reason I say that is because, as was said before, there's a presupposition in what's just been said that it will automatically be cheaper if it's Commonhold, and I don't know necessarily that it will be. Other existing rights, such as the right to enfranchise and the right to manage, will put the democratic control of the management of the property into the hands of the leaseholders, the unit holders. And so it's that position which needs to be contrasted with the existing. So given the commitment of government to strengthen enfranchisement rights, given the commitment with LAFRA, which sits on the statute books, which is yet to be implemented, there are a number of existing rights which are available to people. And whilst there might be a degree of political excitement about the idea that one might be able to get rid of leasehold, to ban new leasehold flats, and require everyone to convert to Commonhold tomorrow, it probably can't work like that.
Okay, thank you. Emily, Philip, anything to add?
Well, my fellow panel members are probably better placed to comment on the day-to-day, purely from a land registration perspective. And we anticipate that future transactions should be more straightforward.
There is an anomaly here because at the moment most leases require landlords to act reasonably, and the legislation for service charges under the 1985 Landlord and Tenant Act requires landlords to charge only what is a cost that are reasonably incurred and where the work done to a reasonable standard. None of those provisions will apply in Commonhold. Commonhold will have a rule, if it is passed as envisaged, that the majority of unit holders pass a budget and that's what's going to be spent, and they have the decision-making process in relation to the running of the block. There is no requirement, no general requirement for them to be reasonable in what they're doing. And this is particularly important in relation to a conversion where people have bought flats on the basis that there's a known regime in the block for the management. They know whether it's a well-run block or not a well-run block. They know whether they can have cats and dogs and things or not. And you hand it over to the flat owners and say, okay, a majority, or even not a majority, 50%, which is not a majority, of course, can decide to have a community statement that says, oh, everybody can have cats and dogs, and it doesn't matter what we do, and we'll fix the roof when we want to. That is a completely different regime, and some individual occupiers might not find it a happier position to be in than leasehold, where you can complain to the landlord if they're acting unreasonably.
Andrew.
So it's very brief. Really interested in that, but we've had a lot of evidence already, and I can say with a degree of certainty that there are a lot of people who are currently leaseholders who will not be of the view that landlords, freeholders have behaved reasonably, and just because it exists in legislation doesn't mean it has played out in reality. So I think that's are you of the view that there are freeholders that are all acting reasonably in line with the 1985 Act at the moment? Because I'm not.
I think the problem is that tenants very often are not aware of their rights and or find that enforcing the rights is difficult and cumbersome and requires going to lawyers and so forth. And therefore the law provides that landlords have to be reasonable. In practice, there are lots of landlords who are, and there are lots of landlords who aren't, and tenants find it difficult to enforce the law. Simply changing the law doesn't necessarily solve the problem. It's a behaviour matter. And unless you change behaviour, you can change the law as much as you like, and you won't achieve anything.
Okay. Thank you. Lewis.
So I've got a few questions about conveyancing. So I think most of us can agree, well, particularly on this committee, that I suppose managing agents are the biggest baddies in the leasehold and commonhold system, and closely followed by solicitors and conveyancing, because I don't think they actually point out to people what they're buying, what the historic service charges are, how much they've gone up over the last couple of years, what you're responsible for, what it's likely to go up in future. I think they just hand loads of papers to the buyer, say sign here, here's your flat, happy days, off you go, here's your leasehold house, happy days, off you go. So do you want to comment on what you think the conveyancing process can do to do better, and what they should be pointing out to people?
Can I come back to that one first of all? So I think there's a couple of things here. If I think about why we set up ALEP, the Association of Leasehold Enfranchisement Practitioners, it was because people found it difficult to get good quality advice about what were quite complicated property rights. It's about education and training, and it's about quality assurance within the provision of that. If we look at why we're here now today, and we look back to 2017 and the so-called leasehold scandal, the reason for that is because people pursued the race to the bottom in terms of the, inverted commas, quality of conveyancing that they wanted to pay for, and they ended up going to what might be said to be a factory conveyancing outfit, which simply waved matters through. The people didn't read the clauses, they're doubling ground rents, time-bomb ground rents, and ended up with unsaleable properties. And unfortunately, it's people who were squeezed financially that were at the worst end of this, because they were the people that pursued that route and were unfairly taken advantage of. So I think the key thing is to ensure that there's education and training, both for the public about what these rights involve, and also for the professionals. And there are lots of bodies that do a very good job in relation to this.
Hang on, but what do you mean education and training for the public? The public go out and get a solicitor who should be advising them on all of these matters. We don't need to train the public to say, this is what you need to do.
I'm agreeing with you. I agree wholeheartedly. I think it's the job of the responsible solicitor to take the appropriate time to explain to the client what they're buying, so they can understand the nature of the asset. And I'm sure that Philip and Law Society will say more about this. I mean, there's the quality conveyancing scheme. It's about the appropriate badging and referencing of professionals that understand what they're doing and that take the time to explain. And the understanding that if you go to buy what is probably the most significant purchase in your life, a significant asset, that the appropriate time is spent on that. And if that means paying fees for that advice, that's probably okay at the end of the day, because it's a very significant life step. It should be taken properly with someone appropriate stand by your side. Philip.
Yes, I completely agree. I mean, there is always the problem that you get what you pay for. And if you want to get cheap conveyancing done, you won't necessarily get as good services if you were paying a fuller price, if you like, for the most important transaction that most people have in their lives, which of course is why all this is so important, because you've got to get Commonhold right, because it includes people buying their own homes, and buying their own homes are the biggest transaction they have, and they need to be aware of what they're doing. They need to be given all the advice, as you say. It will help in practical terms if the documentation can be standardised as much as possible, because then once people are given precedence of reports to the clients and guidance packs and so forth, if the documentation for Commonhold can be standardised, so the Commonhold community statement can be as standard as possible, and in every, let's say every residential block, you know if you're responsible for the window frames or not, and whether you can make noise and stuff. If it can be standardised, then there's a greater chance that people will be given the right advice, because it's not something that the conveyancer has to relearn every time they get a different transaction. They have to look and see, are the rules for this block the same as the rules for that block? And in the real world, standardisation will help to get better information to the people who need it. Plus, as was mentioned earlier, if buyers are required to run the companies, the Commonhold associations, they do need to be told what their obligations will be, whether they're accepting liability under the Companies Act, for building safety and so forth. There will be a lot of obligations imposed on the people who run things and who actually stand up and are willing to do it. And that is an essential element of a Commonhold, because it's being managed in common, and the people who are doing it need to be shown how to do it.
Anyone else want to comment on that? No?
Yeah, I think
Yep.
really just to confirm what Philip and Mark have said is that education and the training is key. We have a case study where last year one of our sales offices did sell a flat within a block which had been converted to Commonhold. There were 4 flats in the block, and the difficulty with that was not necessarily in terms of the block and the management. You know, the 4 flats were on board with it. Apparently the management was running quite well, everyone was quite happy. The problems came with really selling that unit because the agent hadn't come across it before. Trying to find a conveyancing solicitor for the buyer was difficult to get the right advice. And in the end actually went to an overseas buyer who didn't need a mortgage because the lending then became an issue. So I do think that education and training is key across the board for conveyancers, owners, agents, basically anyone that's going to transact with these properties.
And you don't reckon the market then is ready? So if this bill passes and it is default Commonhold, you don't think the market as it currently stands with the solicitors and the conveyancing process is ready for that big change?
No, I don't.
No, I'd echo that. I think one of the things we'd like to know is where we're going to go with further implementation of LAFRA as well, because when we look at some of the things that we're here to talk about today around conversion and some of the more complex parts of that, the valuation side of LAFRA needs to be resolved before that can move forward. And I think that will also impact on people's willingness to understand how it's going to work. All these points around voting comes back to the point we made a moment ago, which is that if it's mandated for new builds, and our question to you would be, let's look at the timing, the rollout, how that's going to happen, then there is the chance for lenders to get comfortable with it and for the market to get comfortable with it before we start looking at turning every single block which is enfranchised into Commonhold.
May I add 2 points to that?
Very quickly, please.
Firstly, I think if it starts with estates of houses rather than blocks of flats, that would be a way of doing it most easily for the technical legal reasons that the documentation will match what's being used at the moment. Okay. The other thing is that you asked a question as to whether or not when the bill is passed, whether we can get cracking, and the answer is no, because there's so much reserved to be in regulations. And without seeing, for example, the Commonhold Community Statement, there is so much to be in regulations that until we see the regulations, we can't even start preparing the detailed paperwork or the training and guidance because so much is left to be in regulations.
Chris, very quickly.
I'll just come back on Mark's point. I think you were talking about enfranchisement, but let's say we do phase it and we park that for a bit. Is there not still a worry that the industry, particularly lenders, are not going to be in a place to accept Commonhold on the day we pass all the secondary legislation?
Well, I'll go back to what Vanessa said. I mean, that seems to be the case at the moment. I mean, some lenders are more comfortable with it than others, but it is difficult to consider with a number of unknowns how that's going to be workshopped. I know you're going to hear from the lenders next week, I believe. So it is a question for them to get comfortable with it as an asset class.
Okay. Andrew, sir.
Thank you, Emily. The Land Registry is going to have quite a central role in the establishment of Commonholds, I think, in the legislation. The Registrar has mentioned several times, isn't it, in terms of documentation that needs to be lodged. From a Land Registry perspective, what's the process going to be for developers and for leaseholders looking to convert to Commonhold?
So I'll keep this fairly high level, but I can provide additional detail after if useful. I think probably the first thing to say is that Commonhold, as it currently exists, is a concept with which Land Registry is familiar, although we haven't had many come through the door. For developers, whether it's a Commonhold development or a leasehold development or a freehold development, we offer services pre-completion of any transaction where we can work with developers to look at skeleton documentation. We anticipate that we will be continuing the service we currently offer to consider the Commonhold Community Statement and approve that ahead of completion. And we think we will work with developers on the account management side to help them through that process. So before they get to the point of actually transacting and selling units, they will have had quite a bit of contact with us if they want to, in terms of getting everything ready to go so there are no hitches when they come to sell.
That works for new developments. Okay. What about for conversion?
So conversion, I mean, these are fairly technical processes. We do anticipate that it will be somewhat more streamlined for people, because instead of having to go through what is probably a collective enfranchisement and then a Commonhold conversion process, it will feel more like one process for people going through this. We have staff who are expert in land registration, and we will need to work on expanding that capability as the market increases their
Indeed,
appetite here.
and the land registry has been criticised in recent years, hasn't it, for the extent of the backlogs. And I understand that you've made some significant progress on getting the backlog down for new applications, but we've received evidence on the committee that significant delays still exist for non-urgent applications. I think that for public confidence to be brought to bear on the Commonhold process, the Land Registry will need to get a grip of those backlogs and ensure there aren't unnecessary delays in Commonhold conversion and in any new Commonhold registration. So what steps are you taking to prepare for that?
So I think the first thing I'd like to say is to acknowledge that our service is not where we want it to be, and it remains a priority, bringing down the backlog and improving the speed of service for applications more generally. We are committed to making the investments needed to deliver these reforms. It's a priority for us, and it's a priority for our sponsor department. And we will need to have ongoing conversations with them around prioritisation of the different deliverables. But in terms of the specifics, we are currently working through with them the design of the processes that we will be using for Commonhold. At this stage, as fellow panel members have said, a lot of the detail is still to come through. But we anticipate from a capability perspective that we will be able to train our caseworkers to deliver this to the timescales currently proposed. We do have experience of training nearly 1,000 caseworkers a year on more complex topics as they progress. And from a capacity perspective, in terms of the number of people, we are working on automation of the simpler applications. That won't affect Commonhold, but it will free up people to be available to process those. And with the phasing as currently proposed of the implementation, and with the displacement of current leasehold enfranchisement applications to Commonhold applications, we think we will be able to manage the volumes. But we do need to work this through as the measures become
So you're not
clearer.
anticipating capacity problems right now, but it's too early to say.
Yes.
Could I just come in on that and say that, as ALEP, we support very much the resourcing of both the Land Registry and the Tribunal Service as well, because they're going to be key to supporting the successful delivery of the Commonhold project.
Right. Okay.
And I think there is a resourcing issue there that will be addressed.
What work are you doing to prepare your online services for this? I think currently it's possible to do a straightforward land registry search, but virtually every other kind of document you have to fill in a form and send it off to the land registry, which really isn't good enough, is it, in the 21st century? So what work are you doing to prepare your online services for Commonhold, so that, for example, a Commonhold community statement will be available for someone to very easily access if it's been lodged? What other types of documentations can be available through your online service?
So I think probably the first thing to say is that there is a difference in service experience between professionals who can access documents through online services and through ordinary people who tend to have to use
completely fair,
paper.
but it'll be ordinary people living in Commonhold blocks who may want to refer back to their Commonhold community statement sort of at a glance.
And so we are we don't yet have detailed plans, but we are aware that we need to make the Commonhold community statements readily accessible. As you say, they can be accessed through a paper form, but we do want to improve that for the ease of day-to-day running and for transparency as well.
You want to, but have you got plans in place
We
to
do
do
not
it?
have a detailed plan at this stage, no.
Okay. Do you think you will do by the time the Act is passed?
By the time the Act is passed, potentially. We do have ambitions to be much more digital in the future. It's in our current strategy. I don't know yet exactly what that will look like.
Mark, did you want to add anything to that? You look like you did.
No, only to add that I think that the current, as I understand the bill at the moment, the enfranchisement will still be the route to Commonhold. So you can take your block, you can buy your freehold. You'll then have the election to decide if you want to make that further application and then convert into the Commonhold status. And I think before you can understand how that will work in practice and what that will look like at the land registry, for a simple block where there's maybe 2 or 3 flats and they've all participated, that might be a very straightforward process. But some of the provisions around non-participants are quite complicated, and some of the valuation provisions around non-participants are also quite complicated. The previous panel has alluded to that. And I'd urge this committee to look into that quite carefully, because when we consider what will happen to somebody who hasn't taken part in the collective after completion, they'll have this right to buy in. They'll be able to serve a notice under Section 52, but we don't have any sight of any regulations about how that's going to be valued or how that's going to work. And indeed, the owner, in a post-enfranchisement scenario where LAFRA has been implemented, will, of the unit, the Commonhold unit that belongs to the non-participating unit holder, former leaseholder or leaseholder, is the former freeholder. And I think there are a number of issues about how those interests are then divested on sale. And we may not have time to come on to that now, but we would certainly like to address you in writing on that, because we believe there are some serious
really
issues to be addressed.
I think that's a key. That would be helpful for us.
The other thing I'd say on that is it would be really helpful to see the proposed workarounds for the valuation reform in LAFRA, which Mr Pennycook wrote to you about on the 12th of February. He suggested that that would be dealt with when this legislation is brought before the House. That's entirely appropriate, but I wonder, in the interest of democracy, whether we could see some of that now.
We are pushing for a number of documents with the department. Andrew, were you?
I'm fine.
Thank you. Chris, very quickly.
Just push a little bit more on the digitalisation point, Emily, because it feels like the Land Registry has fallen quite far behind, at least where the private sector is. In fact, in fairness, behind lots of other parts of the state, and it comes up on a lot of the work we do as a committee, as a general recommendation. So. And it didn't feel like there was a sort of massive amount of ambition to get there quickly. So what's the constraint on moving quickly to digitalise? What's the challenge? And what can the government be doing to help you overcome those challenges quicker?
So I think, firstly, it's fair to say that we share government's ambition to be more digital and to use modern technology. AI, for example, is something that we are currently using. In terms of constraints, there was a period of underinvestment in government services more generally, but also in Land Registry. And a number of our systems are, I would say, legacy systems, so we have to do quite a bit of foundational work before we can then modernise. In our spending review bid, we did cover the sorts of transformation that we want to do, which both includes making our data more accessible, but also digitising services.
Were you successful with that bid?
We were content with our spending review bid outcome.
In that sense, and back to both Andrew and Chris's comments, then we will, hopefully, the Land Registry will be able to modernise by the time this comes through, or will there still be challenges and hurdles that you feel that internally the organisation will face?
It will not be a quick process to modernise our systems and to resolve our data foundations and make them truly interoperable, but it is something we're committed to and are currently working on.
Thank you. Just finally, just wanted to come on to the Law Commission recommendations and implementation. Obviously, you have a situation where currently leaseholders have to pay the landlord in respect of any development value. What impact do you think, to you, Mark, what impact do you think development value would have on enfranchisement premiums for leaseholders, and is this something that we should be making sure the government address in a final version of the bill?
Well, it's interesting, isn't it? I think it's something that, the Law Commission made this recommendation that there be a way in which development value could be ring-fenced in favour of the former freeholder. So not only is the former freeholder also taking lease backs, or what some practitioners would call common backs in respect of non-participant units, they'd also be required to postpone receiving any value for the potential of future development by way of some kind of overage provision which would then sit on the title. It's not yet clear to me how that might be workshopped through from a conversion from an enfranchised situation into Commonhold, how that interest would then be protected, for instance. But I think there's a contrary position for government and policy here, because we've had a relaxation of planning, the coronavirus regulations, the 2020 relaxation of planning, and we've got an ambitious government that wants to build more homes. And so freeing up what could be effectively brownfield sites, effectively rooftop development, for instance, often one of these development value areas, would allow the provision of more homes. So to put something in the way of that might not be to the best advantage. We see many blocks where people will want to buy their freehold because the freeholder is seeking to do something, so precisely so they can prevent that happening.
Yeah, I think one of the other points, I completely agree with what Mark said, one of the other points as well to make aware is how the valuation works. When leaseholders are collectively enfranchising and they pay a development hope value, it's the hope that that development might happen in the future, and therefore that discount on value or added premium is more so than if the development was happening on day one. So I think we've got to be careful as well that if we did defer development until when it did happen, one, what would be the valuation date? Would it be that, or would it be when the enfranchisement took place? But also then it's happening. So therefore leaseholders could actually end up paying more than they would if they paid development hope value, because effectively that's happening
But you
now.
remember I asked about non-participating leaseholders, in essence. Could there be a loophole where they could essentially get out of contributing to that final development value by joining the Commonhold at a later date?
I'm very glad you've raised that point, because I think it goes to the point that I made a moment ago about the position of the non-participants in the post-enfranchisement scenario and indeed the post-conversion to Commonhold scenario. Because in the conversion to Commonhold, those non-participants have this right to buy out the Commonhold of their unit. That's a right exercised under Section 52. What's not clear to me, or to anyone I think, because I don't see any draft regulations anywhere, is how those interests are going to be valued. And so if you want to incentivise collectives to happen, one thing we don't want to end up is in a situation where these people later on could potentially buy in, and if they're required to reflect back on the valuation mechanism under LAFRA, which effectively values this as if it's a lease extension, they may not have to contribute anything towards the cost that the collective has endured to buy the freehold in the first place. And that's not just in respect of development value. So let's say we could take that off the table. Let's just look at the other areas within the building, common parts, other things that have to be purchased in order to buy out the freehold interest. So I think that's something that does need to be looked at very carefully indeed. And if we go back to the work the Law Commission did on this, you mentioned the Law Commission a moment ago, after they published their paper in July 2020, they were commissioned to look at what was called the right to participate. So you may know this, but at the moment, no one, if a collective's gone through, there is no individual right to later buy into the freehold. It can be done on a voluntary basis, but there's no compulsory right. And one of the reasons the Law Commission parked that discussion was because they recognised the valuation of that occurrence was quite difficult to deal with for the very reasons I've just mentioned. How do you properly reflect back the costs that the others have incurred? And so I think we might be going to a situation where the same things could arise for those people in an enfranchised scenario that converts to Commonhold. So it's something we've got to look at very carefully.
Yeah, okay. I think just very quickly, just to add on that point, I think the valuation, I think you have addressed earlier this morning, is the biggest area of concern, both for the bill, but also the outstanding points on LAFRA. We're still awaiting consultation on the rates and the secondary legislation for that. And I think really that probably needs to be addressed first before then talking about the valuation impacts of the bill.
And that was going to be my final question in terms of are there specific areas that the government should focus on from the Law Commission recommendations? Maybe should they look at right to manage process as an alternative option, or would you say there are other areas that...
I think it probably comes hand in hand in both. So right to manage is definitely the cheapest of all the options. With that comes the regulatory of property managing agents, which I think we probably all agree that we're all in favour of. But then with that has to come the outstanding situation that we've got with LAFRA. We've got a legislation there that's sat not doing anything, which causing so much market uncertainty. Which really needs to be rectified before we even talk about converting to Commonhold for these existing buildings.
Loud and clear, get on with it.
Yes.
Thank you very much for coming before the committee, and it will be good in terms of any follow-up reports and items. Thank you. Order. Order. Welcome to the third part of our discussion this morning on the Commonhold and Leasehold Reform Bill. Could I ask our guest to introduce himself, please?
Yes, I'm Richard Best. I'm a crossbencher and independent in the House of Lords. I gave my maiden speech on the Commonhold and Freehold Reform Bill 2002, 25 years ago, but I chaired the Regulation of Property Agents Working Group in 2018-19. I'm still waiting for it to be implemented. Yeah.
Thank you for coming before the committee this morning, Lord Best. Will.
Thank you, Chairman. Lord Best, my constituency of Woking, the top issue that is raised by constituents is housing. And one of the common themes is rogue managing agents. It's a wild west out there. We have got awful examples of customer service. The fact that they're not regulated is a great injustice, is my view. Why do you believe this bill doesn't lance that boil and correct that historic wrong, the thing that you've almost campaigned for since you came to this building?
Right. Well, first of all, I think regulation is unfashionable. So there are voices that say don't regulate, it'll be anti-growth. I think it's an absolutely false argument. Good regulation actually gives confidence in an industry, it builds trust, it's about growth, it helps growth, and the industry itself welcomes, wants. I think you've heard all your witnesses from whichever part of the sector they come from. They all say that regulation would be a good thing. So I think that regulation being unfashionable should not be an inhibiting factor. The best interpretation of government doing very little about this is that they're waiting for a moment for a really comprehensive, proper regulatory bill, a separate bill that would cover letting agents and estate agents as well as managing agents. We'd have a proper, comprehensive bill with a proper regulator. If government says that's what they're going to do, well, I'll be patient and wait a bit longer. But I think the real reason is lack of resource within MHCLG to get on with handling this. I mean, it requires 3 civil servants for 3 weeks, by my estimation, a very vague back-of-the-envelope estimation, but it needs people on the case to actually get this together. The Office of the Parliamentary Counsel, Michael Gove said, is lacking the capacity for it to intervene, write the legislative clauses, do the work. If only people would get to work on it. It isn't that difficult. There's a lot of stuff out there already. We've got Danny Beals's private members bill already drafted. I think it wouldn't take too much, and government should get on with it. But I think it is the complexity of the bill, all the other things getting in the way. They haven't had the resource to embrace this element as well, but they should have done.
Thank you. A follow up on 2 separate things. What discussions have you had with ministers, particularly Matthew Pennycook, who I know has highlighted, not via this bill, Will, but maybe via another bill, we might tackle this issue? What discussions have you had with them about other legislation to regulate managing agents? And both yourself and then Lord Gove last week highlighted, effectively it's the Treasury stopping this because they're concerned about the financial impact. I agree with you that actually providing certainty for the sector and giving confidence to consumers that it's safe to buy a flat again would be really helpful. But what concerns do you have that the Treasury is blocking this?
I don't think Treasury is saying this is going to be incredibly expensive, because it isn't. You know, a modest levy on 5 million leaseholders, even if all of it is passed on by the managing agents, can pay for an awful lot. There might be a need for some seed corn at the beginning, which Treasury would have to stump up just to get things started. But this will be self-financing, and it shouldn't be. I don't think that's really an argument. I think it is the sheer complexity of all of this. We've heard how complex things are just today, and dealing with 121 Law Commission recommendations does require a lot of input and a lot of civil service time, and this hasn't been allocated to cover this, unfortunately. Mm. Oh, and just in terms of meetings with Matthew Pennycook, I am meeting him again in about a week with Danny Beals, who's done the private members bill. Matthew's always been very sympathetic, and in opposition, politicians in both ends of this Parliament have been very favourably disposed toward regulation. Just getting round to it, getting the clauses together, getting the legislation packaged properly, it's been low on the list of priorities.
So the Minister's not said no to regulation at some point, it's just they're working on it, they're considering it, it's low list on the priorities.
The Minister said yes to professionalising the sector, to qualifications, to including, Steve Reed has mentioned this, the lettings agents for the private rented sector and the estate agents for the sales sector. All sweet words of comfort for me, but not actually in the bill.
Sean and then Chris.
Lord Best, last week we heard from campaigners on this issue that they actually didn't want regulation of managing agents because they were concerned that that would actually just pass the costs on to them as leaseholders. Do you have any comment on that? Because that would seem to me to be a fairly important piece of testimony.
Yeah, I think that this shouldn't be incredibly expensive. Managing agents are bound to pass the cost on one way or another, or at least most of the cost. I suspect that's what happens. But it isn't spread across, a regulator spread across a whole industry is not a huge burden. I think they're worrying unnecessarily, especially if we can get government to give the start-up costs. You've got to appoint somebody, get an office, do those things before you get going. And if that's done by government, a relatively modest input from government, we talked in my working group about 5 million, maybe 10 million. Yes, it's annoying, but if government puts up a certain amount of seed corn at the beginning, then the thing can run itself thereafter relatively inexpensively. As I was saying earlier, 5 million leaseholders, £3 a year, that's 15 million. That can run a pretty good regulatory system.
And was that what you referred to in terms of self-financing?
Yeah, those sort of numbers. If everybody was paying the levy that the managing agent has to pay, if that was being passed on to the consumer, then there are 5 million consumers, leasehold. Mm-hmm. It's annoying, but not the end of the world.
Yeah. Chris?
Just in terms of process, we're obviously doing the scrutiny of the legislation, and this is an important part of that. From your conversations and your work over such a long period of time, what do you think it would be useful for us to say in order to continue to push for the debate? Do you think it would be easiest to say, put it in here? Do you think it would be easiest to go, okay, it can't go in here, but let's do another piece of legislation as soon as we can?
I think that would be good, although parliamentary time is precious. MHCLG's had an awful lot of the parliamentary time. It would be a few years before we see the end result. So although a comprehensive bill would be exactly what's required, I suspect the delays would make that difficult. We are promised already qualifications, mandatory qualifications for agents. So there's something coming down the track. My argument is extending that to cover a code of practice and then enforcement of that code, which is what you get a regulator to do, that isn't such a big extra to add to what government is already committed. I think we will get the qualifications in the bill. So there's going to be stuff in this bill. And if we're going to get anything in, why not get the whole, go for it while we're at it and have a regulator?
Sarah?
And just your sort of first argument and point, would there be other areas where you would point to in terms of that demonstration of how a regulator has actually enabled growth as compared to been a barrier for it?
I think, well, every regulator would probably tell you that they're doing a great job and making the industry safer, but also helping it to grow. I'm afraid that the examples that one tends to quote are those where it hasn't worked, and regulation hasn't worked where there's numerous different bodies doing the regulating. So you need one body, one mind. I think you want a single focus. And regulation hasn't worked if it hasn't been properly enforced, if the regulator hasn't got the powers to actually make things happen. In this case, fines, reprimands and gentle things to start with, but building up to you lose your license, you can't operate, you're out of business. And there's no good setting up a Phoenix company tomorrow because it's you that is out of business. You have the license as an individual, as well as your firm being registered. So I think that there are bad examples of where regulation can get in the way, but we learn from those lessons, and the lesson is don't confuse everything by having a lot of different bodies all involved in the regulatory process, and concentrate your firepower, and good regulation works.
And if perhaps stepping back, the main goal of this whole area of legislation is to try and fundamentally reduce the costs to the individual of owning and managing their property, if that was one of the driving priorities, what do you think are the risks going forward as we are with the bill as it stands to achieving that, based on the impact management agencies have on that issue of cost?
Yeah. The managing agent does have an influence. This has been played down by some people. They say, well, even if you enfranchise, look after it yourselves, have the powers that Commonhold would bring to you, you'd still have the same costs of a managing agent. I don't buy that. A lot of these costs are to do with the managing agents themselves. They're to do with the scams at the worst end, but they're just to do with the ineffectiveness, the extra charges, the commissions, the permission fees for all kinds of stuff. I think there's a lot of savings which, if you were in command instead of some freeholder and you were controlling and you can tell the managing agents that, I'm sorry, you're going to have to go. We're going to get rid of you. We're going to appoint somebody else. If you have that power, I think costs come down. They don't go up. So I wouldn't worry about increased costs. The increase will come from recognising that you need to set aside money for a reserve, for a sinking fund for the long term. But when everyone can see what's going on, when this is explained, and it may be irritating that you've got to put aside money and you're planning to leave in 2 years' time, and you won't be there for the new lift, but you understand what it is that the money is for. Yeah. This is spelled out. The
transparency element, that's the key thing that comes back to us.
Absolutely.
People receiving bills for work which is so opaque they have to go through line by line. Then when they do go through line by line, they actually find they're being charged for something that doesn't relate to their block at all.
Right. Right, and at the very best they get, oh, sorry, we didn't notice that. Apologies, we won't do it again. But people need to feel threatened that they can be fired. And I think that one of the main advantages of Commonhold is you're in charge. You can get rid of the managing agent, and they know that you can get rid of them.
Sarah. And I think you have to some extent sort of clarified this, but your position, if there were to be further provisions brought forward in this bill, you would be prioritising the code of practice, but really would like to see all of the recommendations from your working group brought forward into this.
Yeah, I think the key thing is to have a regulator. Government at the moment is talking about using designated professional bodies. That's the RICS and the Property Institute, TPI, to do the work, and then spread some of it amongst duties on trading standards officers, some to do with the Ombudsman Service.
All who are overstretched at the moment.
All kinds of overstretched people, theoretically giving this a new priority, and no regulator, no single mind behind all of this. So I think my key one is, yes, qualifications, that's really great, but just being qualified doesn't necessarily make you behave properly. You still need a code of practice, and you still need enforcement. You need an agency, that's what they do. They enforce the code.
And might you agree that resources invested in those alternatives would not be the best use of public money versus the opportunity of a regulator?
Absolutely. I mean, if you're going to spend the money, spend it on a regulator. But I think also there are conflicts of interest. If we're going to give this job to professional bodies, who are dependent on the subscriptions from their members. They've got to be nice to their members ultimately, and it's quite difficult to also be the regulator. And it's not your top priority. This is a secondary business. Let's have a regulator.
A new one.
A new one.
With enforcement powers.
Precisely.
As opposed to a letter saying you've been currently suspended, but then you can come back.
Exactly. We don't want any of that nonsense.
Thank you very much, Lord Best. I think this is an issue that will continue to come up as we discuss the Commonhold and Freehold legislation in full before we get the final bill. Just to thank all our guests for coming this morning, and for people following and watching. We have a range of guests appearing before the committee next week. Order.